the things that can go wrong. All right, so you've signed a deal up with the owner. You've sublet it to a tenant. You got some money from them up front. You promise you're going to sell it to them at some point, and you will do so when you exercise from the owner. So what can go wrong? Well, the seller stops making his mortgage payment. I'm paying the seller every month. The next thing I know, my tenant calls me up and says, I got a foreclosure notice on my door. Now you got two lawsuits. One against him, which he'll lose because he's dead broke, and one from the tenant against you because he's losing his option. If it gets foreclosed, his lease and option are gone. It's wiped out. Okay. So how do we prevent that? Well, when I say we're going to pay the seller, I don't really mean we're paying the seller. You have a couple of options. You could pay the mortgage company directly. So if you're optioning it for a payment that is his mortgage payment, and it's $1,262 a month, and that's what you're paying him, there's no reason to pay him and hope he pays it to his bank. You pay it directly to his bank. Just get his coupon book or whatever, or statement mailed to you now, and you pay it. Okay, you might be a little sketchy about that one. So another option is you can use a servicing company. There are companies that will collect the check, send people statements, and then make the payment, especially if the taxes are in escrow. They can escrow the taxes and the insurance and pay it out accordingly. Okay, so a neutral third party does it. But that costs money. It costs $20 to $30 a month. And $200-300 up front to set it up. The most practical way I like to do it is, let's say, Mr. Seller, what's your bank? Chase. You have an online account with Chase? Yes or no? If not, we set one up. And then it says direct draft out of your bank account automatically. What do they ask for? A name? No. What do they ask for? Routing number, bank account. Instead of his bank account, whose bank account is it coming from? Ours. And we're both notified by email every time the payment's made or every time the payment's due. Got it?
There's no fears about providing that bank account information?
We're not providing the bank account information to the seller. We're going to go on account, I'm going to go turn around, and I'm going to enter my stuff. And once it's in there, it just says account ending in 4129. That's it. I'm not giving him the routing number. Besides, even still, he's not going to. I wouldn't worry that much about it. There's so much information about you. Everyone crying about this iPhone thing. Your employer and the government has so much information. Everyone goes, I don't want my private information. Amazon knows more about you than your friends. Funny story. My daughter put on a few pounds. She's not fat, but she put on a few pounds.
You're in trouble.
No, I didn't say she was fat. Not to her face. Anyway.
You better not see this.
Nah, she doesn't watch it. So anyway, we get in the mail a plus-size catalog. How did the hell did they know that? And addressed to her. So my son saw it. I go, don't you even mention this to her. I put it in the garbage. You mention this catalog, I'm going to ground you for a month. And what did he do? He got into a fight with her a day later and told her. All right, so that problem solved, right? The seller not making his mortgage payment. Now, the seller refuses to complete the sale. Like, we get to the end and they go, I changed my mind. I don't want to sign it. I don't want to sign the deed. I won't sign the closing papers. I don't want to do it. Well, you can sue them. Meanwhile, your buyer's lined up ready to close, and you can go into a 2-year lawsuit with the owner and spend thousands of dollars in attorney's fees. Not practical, is it? No. So, what we should do up front is create an escrow. This is why this is all going to come back around now where it makes sense. Seller signs a deed, a warranty deed to the property, a general warranty deed to the property. Okay? And we deposit that into escrow with a title company, attorney, or escrow company. And with escrow instructions that say very specifically, when the buyer tenders the balance due, that deed is given to the buyer. So we just covered 4 lessons there from this morning. Okay? Deed not delivered is not a set transfer. So he signs a deed into escrow. When it's delivered to the buyer, the ownership transfers. Make sense? We closed in escrow. Seller signed a deed. We're waiting for the money from the buyer eventually. Okay? It's not recorded yet. It's in escrow. Does that make sense? And typically we do the same back. We have a deed, a quitclaim deed from us back to the seller with instructions that if I disappear, then the quitclaim deed erases my interest. Which I'm not worried about. Just trying to be fair. That's why I explained it to them. Because if I explain, we're just going to put a deed in escrow because we don't trust you. It just sounds better to say, well, listen, if you disappear or I disappear, we both have a remedy. Okay? And I had that happen to me where the seller died. Seller died. Now, normally we'd have to go to his estate, and if he didn't open it, like let's say that was his only asset, and none of his kids opened up an estate, because nobody could sign the deed for a dead guy except the executor or executrix of the estate. So they have to open a probate proceeding. And if nobody did that, I got to hire a lawyer to do that, which can cost $4,000, $5,000, $6,000, $10,000 depending on what state you're in. Okay? So the deed in escrow was there. He had signed it before he died with absolute instructions. Now, there was an executor. I was dealing with the son. The guy was a doctor. Kind of a big shot doctor, too. He was a pretty big shot doctor. Tough negotiator, though. Real tough guy. His son called me and says, "What's this deal you did with my dad?" And I explained it to him, and he goes, "No way. I'm not honoring that deal. You stole this house." And this is like 7 years later. Right? And I said, "I'll sue you. You can't do this." He goes, "Then sue me." "I don't care. I ain't doing it." Damn. Called up the attorney who was holding escrow. It was this dead guy's attorney who drafted the documents and held escrow. I said, "Hey, remember me on that deal with Dr. So-and-so?" He goes, "Oh, yeah. I said, "You still got that deed in your file?" "Yeah, I do." I said, "You got a title company?" "Yeah, I do." I said, "Can we close on that deed?" "I don't see any reason why not." We closed without him. Son found out. He called me and left me a message. So many 4-letter words. You don't believe it. But that's what protected me. Now, it won't work in every circumstance with a dead person. I just got lucky on that one. But there's ways to word it so that you can put it in a trust so that you don't need a probate, and then it automatically vests to the buyer at that point. And there's lots of ways to work around that. Okay, so seller refuses to complete the sale. He can't. The deed's in escrow with absolute instructions. The seller dies. The same thing. Now this is a tough one. The seller filed for bankruptcy. This is the problem. In bankruptcy, the bankruptcy trustee who's assigned to the case has the legal authority to cancel all what's called executory, which means in English, uncompleted contracts. Is this an uncompleted contract? Yes, it is. So he can cancel it. And then I have SOL. And my buyer is SOL. How do you think I know this? Because I did something stupid. I made a deal with a guy whose payment was way more than market rent, and I said, "Well, you're paying $1,500 now. How about you pick up $400 a month, and I'll pay you $1,100, and you pick up $400, which is better than paying $1,500 negative." And he said, "Oh, that works great." Well, he liked that for about 6 months, and then he filed bankruptcy. Don't do that kind of a deal. That's a bad deal to do. Where the seller's upside down and he's contributing, and when you have a conversation, he has no other assets and he's up to his ears in debt. Very big risk of bankruptcy. Very big risk of bankruptcy. Now, can you make a deal with the trustee in bankruptcy? Yes, you can. Maybe get the deed. Yes, you can, if the seller will agree. And that's a reason why, when you do a sandwich lease option, I'd say a year later, wait about a year and a half later, go to the seller and ask him to just give you the deed. Just give it to you. Out of escrow. Just let you have it. Subject to his mortgage. Now, I had a student worked with me in my mentoring program, and he had done 5 or 6 lease options. And I said this to him. I said, "You should go back and get the deed, because that'll cure a lot of these problems, right?" Getting the deed cures a lot of problems. First of all, it gives you ownership, which means you can apply for a capital gains treatment when they exercise. You can do a 1031 exchange at the back end, which you can't on a sandwich. I'll explain later why. The seller dies, the seller, whatever, seller files bankruptcy, doesn't matter. You got the property, and he's extinguished from the debt in his bankruptcy, but you own the property. Does that make sense? And he said, they'll never do it. I said, ask. He goes, I'm not asking. They'll think I'm nuts. Ask. She goes down in his car, says his wife, bill's all wet. And there's no way they're going to do it. I got a call 3 days later. He goes, yay, we wouldn't believe it. 4 of them said yes. And just gave him the deed. Because he had a relationship. He was paying on time. And, people in their mind think having the deed is like having a disease sometimes. Like the deed in their name is a disease, a responsibility of some kind. Even though he's still on the mortgage, just like the husband-wife scenario I told you about. He's still on the mortgage. So it's risky for him if you don't pay. He can't just evict you now, like he could before. But if you establish that relationship and just ask for it, it takes a lot of risk of problems that could happen to him. Like let's say someone gets a judgment against him and then records it. Now it's a lien on the property behind the mortgage. And when you go to exercise, there's a $20,000 IRS lien or judgment or something like that. Ooh, that's a problem. What if you went and refinanced it or got a second HELOC on it? Now, first of all, one of the first things we do up front is we record an affidavit called a memorandum of agreement or memorandum of option, and we record that down at the county. That puts what's called a cloud on title. So when he goes to get a HELOC, the title company looks it up, sees this thing, and says, we got a problem here, we can't insure the title because of this filing. So that'll stop him from doing that. That'll prevent that. Okay? But if you really, if you can't get the deed up front or later, I would say up front what you should do is get a mortgage from the seller to you. A mortgage for what? Well, remember what we said a mortgage was? What was a mortgage? There was 2 things. There was a promissory note, which is a debt instrument, and then we have a security instrument, which is a mortgage or deed of trust. So we'll put your mortgage. So you as the owner of the property borrow money on a note, and to collateralize that note, you give to the lender a mortgage against your property. Mortgage or mortgagee, or the E. The mortgage says this mortgage is given to secure the payment on a note of even date herewith in the amount of $150,000. You ever read a mortgage? That's what it basically says. And it says all kinds of other stuff that if you don't do, we can foreclose. Like not keeping up the property, not paying the insurance, not paying the tax, all those things they can do. Okay? Instead of a mortgage to secure a note, can a mortgage secure something else? Like an option. So the mortgage is recorded against the property to secure the seller's performance on the option. So if he says, no, I'm not going to do it. I refuse. What do? You don't sue him. You foreclose him. Now you've got the upper hand. Does that make sense? It's very easy. You just take a regular mortgage or deed of trust and you attach an addendum that says, this is being recorded to secure performance on an option dated blank. Wherever the word mortgagor appears, substitute optionor, and wherever mortgagee, optionee, and so forth. And then just attach it to a deed of trust and go record it. What's the amount you put on the face of the deed of trust or mortgage? I don't know. I don't know. Maybe you take a stab at what your equity is and multiply times 2. So now, what does that do for you? If he fails to exercise, to let you get the property, you foreclose them. Now, what about insurance? It's hard to get insurance on a property you don't own. You're now an insured lien holder. So if it burns down, first mortgage gets paid and you get paid your equity. Does that make sense? If he goes into bankruptcy court, what are you now? A secured creditor. Secured creditors get first preference. So it's not just a contract that the trustee can cancel. You are a lien holder on that property. Does that make sense? So there's a lot of benefit. Now, the only challenge is, I know it's complicated as you're listening to it, try explaining it to the seller. We're going to put a mortgage in your property for performance in case you file bankruptcy, blah, 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 blah. It's a tough discussion. You're going to have to gauge whether the guy is either smart enough or skittish enough to not understand it. So if he's skittish about everything, don't do it. You're going to confuse the hell out of him. A year and a half later, just ask him for the deed. But if the seller's like, I'll sign whatever, then you just explain it to him, and he'll probably not get it, and he'll go, whatever, and he'll sign. It's good to have that, because it can protect you in a variety of ways. The last thing that can go wrong is your tenant buyer defaults. Wow. Now what? What do we do?
Kick him out and get a new tenant.
Well, how do you kick him out? File an eviction, right? That costs money, time. They trash the place on the way out. What's the smart thing to do?
Offer him part of the money.
Offer them part of their money back. And in exchange for leaving it room clean, and they sign a release of liability. I have a form, it's called a surrender of possession. It means they're giving up possession, and release of all claims against you. Make sure you get them to sign that before you give them the money. Okay? Maybe even get them a moving truck with some guys to help them if they're unable to do so. But it's far cheaper, easier, smarter to settle out of court with a buyer by giving some of the money back, even if you have to give all the money back. Because then you avoid a protracted eviction, potential court delays, or potential, wreck the place on the way out, whatever. Or even worse, leaving all their stuff. Then they get a roll off and a bunch of guys to haul it off. That costs usually more than a couple of holes in the wall. Does that make sense? Just try to settle out of court. Now, if it's a huge difference, let's say they gave you $20,000 down. There's no way I'm giving them $20,000 back. There's no way. Because, an eviction and making payments on a house for 3 or 4 months and possibly damages is not going to cost $20,000 in attorney's fees. It's not going to cost you that much. But, you got to figure, what costs more. Worst case scenario, eviction, trial, sheriff's fees, cleaning out the house, repairs, 3 months of payments on a mortgage that you getting with no income coming in. That costs X. Give the money back to the tenant. That costs what? That costs X. If it's the same thing, just give them the money back.